All right, let's get started here. So we're going to have council do a kind of a wave top review of what is in the speaker's bill, and pull out some of the larger items that are different from what we put forward in our 9 bills. And then he's going to do a full run through, and then we'll come back and ask questions. So if you could help us just do first give us an overview of the speaker's bill, and then just do a crosswalk. So Jamie, over to you.
Thank you, Mr. Chairman. So House Bill 670 covers a variety of topics, many of which were covered in the package of Senate bills that the Senate passed out earlier this session. Just running down the list of topics, the House bill covers topics including no-knock warrants, the use of force, police discipline, as well as officer well-being, disclosure of records under the Public Information Act, body-worn cameras, and also includes provisions on forfeiture of certain benefits, study on 911 services, a provision for tuition repayment and scholarships for police officers, requirements on identification during traffic stops, and a requirement that an officer may not prohibit a citizen from recording audio and video of a interaction with a police officer. It increases liability caps under the state and local tort claims acts, has various reporting requirements, including a SWAT reporting requirement that had sunsetted some years ago from the code, and alters the composition of the Maryland Police Training and Standards Commission, and sets forth various changes to the training requirements and also the certification and decertification of police officers. And I guess if, Mr. Chairman, if there's anything in particular you'd like me to get into, I'd be happy to get into the differences between the police discipline or any other subject.
Police discipline. Right.
Police discipline.
You have that for As we get into the disciplinary process that's contained within the LEOBR, so they prepared a flow chart essentially to help us understand their process. Some of you may have seen it, but we're going to have it sent out to your laptops right now that helps explain. So as Jamie's walking through, you can kind of follow along. All right.
Sending it your way with that. So you should have a flow chart in your inbox on the proceedings, how the structure of the House bill for disciplinary proceedings. If we're going off of the bill, it actually might be easier just to go through that part of the bill. It starts at around page 29 is where the substance of the disciplinary provisions of the bill are. What it does is it requires an independent investigative agency to be established as an independent unit of state government. The duties of the independent investigative agency include the investigations of shootings and uses of physical force that cause death or serious physical injury. Law enforcement agencies would be required to provide notice and cooperate with the independent investigative agency as soon as they became aware of an incident that qualified for an investigation. The investigative agency would be required then to provide reports to the state's attorney, and the report would be published after the state's attorney made a determination on whether or not to charge. So that's sort of an overlap between the disciplinary process and also the criminal process, and these things kind of work in tandem, and you can actually see that in the flow chart that was just sent out, and just starting from the top, the scenario that I just described would begin with the alleged misconduct occurring, and on the left side of the flow chart in orange, state agency would investigate, and then criminal charges could be referred. Moving on to page 30, there's a requirement for each county to have a police accountability board. And the duties are outlined in lines 5 through 14 of page 30. So that would be required to hold quarterly meetings, appoint civilian members to charging committees, which we'll get into in just a moment, receive complaints of police misconduct filed by members of the public, and review outcomes of disciplinary matters considered by charging committees. The charging committees are, as I mentioned, empowered to receive complaints against police officers. If you look down at lines 23 on down, there's are requirements for complaints against police officers. The complaint would need to include the name of the officer, description of the facts on which the complaint is based, contact information of the complainant. This continues on to page 30 as well. Specifically, complaints against officers under the bill would not need to include identifying information of the complainant if the complainant wishes to be anonymous or be notarized or sworn to under penalty of perjury. The next section, I'm looking at page 31, contains provisions relating to complaints made to law enforcement agencies, and these mirror those that I just went over. Going down to the bottom of the page, you look beginning at line 25, there's a provision providing for county administrative charging committees, and each county is required to have one administrative charging committee to serve county-wide law enforcement agencies and local law enforcement agencies within the county. This would make up the, if we're just sort of glancing back at the flow chart, the right side of the flow chart, where we have decisions on, or actually would make up the center of the flow chart with the administrative charging committee. It's outlined in yellow on the center of the flow chart. So each county charging or administrative charging committee is required to be composed of members that are outlined on page 32, line 2 down. The composition would need to include the chair of the county's police accountability board, a designee of the district public defender who is a resident of the county, not employed by the office of the public defender, and not currently representing a party as an attorney in a criminal matter pending in a court in the county. The board would also need to be composed of a designee of the state's attorney for the jurisdiction, who as well is not a resident of the county, not employed by the state's attorney, and not currently representing a party as an attorney in a criminal proceeding. Would need to include one civilian selected by the accountability board, the lead attorney for the superior governmental authority in the county, and then at the bottom of the page there in B, there are provisions for a statewide charging committee. This committee would be responsible for bringing disciplinary charges against law enforcement officers in state law enforcement. And there it outlines the members that would need to be included in that. Designee of the Attorney General, designee of the Public Defender, designee of the Governor's Legal Counsel, one civilian appointed by the Governor, and one civilian jointly appointed by the Speaker and President of the General Assembly, Speaker of the House and President of the Senate of the General Assembly. There would need to be training that these members would undergo before participating. And essentially what their function would be is that on completion of an investigation of a complaint made by a member of the public against a police officer, the law enforcement agency would be required to forward to the appropriate charging committee the investigatory files. The committee is then required to review the findings and make a determination whether the police officer should be subject to disciplinary proceedings or not subject to disciplinary proceedings. If the officer is charged, the charging committee would recommend discipline in accordance with a disciplinary matrix required to be established by MPTSC later on in the bill. They would also be required to issue a written opinion that describes in detail the findings of the committee, determinations, and recommendations, and then forward all of this to the chief of the law enforcement agency as well as the citizen complainant. The charging committee also has the ability to request information or action from the law enforcement agency that conducted the investigation, including requiring additional investigation and issuing subpoenas. If an officer is not administratively charged, the committee can make a determination that the allegations against the officer were unfounded, or also exonerate the police officer. The committee is also in a position where, and I'm looking at lines 8 and 9, they're able to record in writing a failure of supervision that caused or contributed to the police officer's misconduct. So each month, each charging committee is required to meet, and they would make determinations from there. Lines 15 through 20 provide for that uniform disciplinary matrix that I mentioned, and lines 21 through 25 go over the process for the recommended discipline by the charging committee and how that process happens, going from the committee to the chief and ultimately to a trial board if necessary. So what would happen is the charging board makes a determination. If they decide that the officer should be subject to discipline, they can recommend discipline, and then that is forwarded to the chief. The chief then, after receiving it, can offer that discipline, or they can offer only either the discipline that was recommended or a higher discipline. but cannot offer a lesser discipline than what was recommended by the charging committee. If the officer accepts the discipline, then it gets imposed. If the officer declines it, then it would go to a trial board. The trial board would need to be composed of 3 members. That would include an actively serving or retired administrative law judge, or a retired judge of the district court or circuit court, a civilian appointed by the county's Police Accountability Board, and third, a police officer of equal rank to the police officer who is accused of misconduct. These members, in order to serve on the trial board, would need to go through training provided by MPTSC on police procedures. And like the version passed by the Senate, which had procedures for a hearing board, the trial board under this bill would be required to be open to the public, except under certain circumstances. In the House bill, these are outlined line 21 on down on page 35. The House bill specifically has a provision that provides for notice to the complainant that the complainant has a right to the complainant has the right to be notified of a trial board hearing and the right to attend the trial board. There are appeal provisions provided for on page 36 and lower on page 36. This begins at lines 22 on down. Provide for suspension pending an investigation, charging, trial process. So essentially that provides that pending an investigatory, administrative, charging committee, and trial board process, the chief may impose an emergency suspension with or without pay if the chief determines that such a suspension is in the best interest of the public. This suspension, if it's without pay, could not exceed 30 days. The officer would be entitled to receive back pay if the charging committee determines not to administratively charge the officer in connection with the matter. On the next page, page 37, beginning at line 4, there's a provision for suspension without pay pending criminal charges. So this provides that pending an investigatory, administrative, charging committee, trial board, and criminal prosecution process, the chief shall impose emergency suspension without pay if the police officer in question is criminally charged with 1, a felony, 2, a misdemeanor committed in the performance of the duties of the officer, 3, a misdemeanor related to domestic violence, or 4, a misdemeanor involving dishonesty, fraud, theft, or misrepresentation. Again, an officer who is suspended without pay is entitled to receive back pay as specified in the bill. Further down on that page, there's a provision for mandatory termination. The chief is required to terminate employment of a police officer convicted or who receives a probation before judgment for a felony, a misdemeanor committed in the performance of the duties of the officer's duties, a misdemeanor related to domestic violence, or a misdemeanor involving dishonesty, fraud, theft, or misrepresentation. Further down, there are provisions that are similar to the existing LEOBR as well as those passed by the Senate in the Senate disciplinary bill for testing and interrogations. That's lines 26 to the bottom of the page on page 37. It also provides for, well, I'll hit this first. If you go to page 38, there is a provision in lines 10 through 13 that provides that in connection with a disciplinary matter, under the subtitle, forfeiture of a police officer's pension may be imposed as a disciplinary action in accordance with a section that comes into play later on in the bill, being added to the state personnel and pensions article. So I did want to note, just moving through, I wanted to circle back at some point to show there are provisions pertaining to officers exercising constitutional rights and political rights that mirror those that were in the Senate version as well as in the current law. But since we're on page 38, just looking at line 14 on down, these provisions provide for, I'm sorry, what?
38.
Page 38. So if you look at line 14 to the bottom of the page, this section, which is section 3.109, provides for victims' rights advocate for misconduct. This victims' rights advocate would be a position within the law enforcement agency. So I'll just read it. A law enforcement agency shall designate an employee as a victims' rights advocate to act as the contact for the public within the agency on matters related to police misconduct. So the victims' rights advocate would be responsible for explaining to the complainant things including the complaint, investigation, administrative charging committee, and trial board process, any decision to terminate an investigation, an administrative charging committee's decision to administratively charge or not administratively charge or find unfounded or exonerating the officer, and also responsible for explaining a trial board's decision. If we move on to page 39, there's a provision also for a searchable complaints database. It provides that each law enforcement agency must create a database that enables a complainant to enter the complainant's case number, to follow the status of a case as it proceeds through investigation, charging, discipline, trial board, ultimate discipline, and appeal. And then I just want to draw the committee's attention to lines 18 through 21. On page 39, provides that the process of review by the investigating unit of the law enforcement agency through disposition by the administrative charging committee shall be completed within 1 year and 1 day after the filing of a complaint by a citizen. So effectively from the day that the complaint is filed to the day that the administrative charging committee makes a determination, that process can only take 1 year and 1 day. And beginning at the bottom of the page, we see, starting at lines 22, officers' right to representation and connection with a misconduct proceeding or a disciplinary proceeding. And then line 26 at the bottom of page 39 onto the next page provide for those rights that I had mentioned earlier. So there are some whistleblower provisions providing that an officer may not be discharged, disciplined, demoted, etc. Under certain circumstances. And those are mirror provisions that are in the Senate version as well as in the current law too. But there are provisions at line 7 for the exercise of constitutional rights, an officer's right to sue, that's lines 8 and 9, political rights, lines 10 through 14, secondary employment, which is on lines 15 through 19, and a provision down at line 20 through 22, providing that a law enforcement agency may not negate or alter any of the requirements of the subtitle through collective bargaining. So just prohibits collective bargaining from altering or negating the provisions that get laid out in the bill with respect to discipline. One of the more notable departures from or between the House and Senate bills are that if you look at line 23 to the bottom of the page on page 40, provides for no expungement or destruction of disciplinary records. So it provides that a record relating to an administrative or criminal investigation of misconduct by a police officer, including internal affairs investigatory records, a hearing record, and records relating to a disciplinary decision may not be expunged or destroyed by a law enforcement agency. So that might be a good time to stop, because I think from there on it gets into MPTSC, but I'm happy to answer any questions.
Sorry, not so much a question, maybe at the end, I'm not sure, but more of a comment. One, from what you went through, there's a myriad of substantial departures from what we did, and so I guess the question is, what is the expectation of us at this point in terms of the things that are vastly different? Are we to re-debate these things over, or what are we to do?
Yeah, so this is all about just getting a base level understanding of how they differ and what they did. And so I suspect folks, I think, internalize this, draft up questions, start thinking about what you'd like to see in the final product. But that's all this session is for today. So when we come back tomorrow, tomorrow's Friday, right? So when we come back tomorrow, we'll be able to have a more informed debate over where we should move forward and what the committee thinks is the right product to put forward on the floor. So today is just to get that base level understanding, develop some questions, move forward. So.
Sorry if maybe I should ask offline, but is this kind of in lieu of conference, or is this a precursor?
This is all a precursor, just so that all the members on this committee understand the two paths. This is all precursor. So yeah.
Thank you, Mr. Chairman. Can someone elaborate a little bit? I mean, this is creating a new bureaucracy. I mean, a new state agency. And I guess, can someone give me a little more context for, or do you know kind of what the thinking was about this? Where does it fit? And who is it comprised of?
I'll ask counsel this. Can you start with just the ACC process and how there's a state level, and then you've got each county is going to be required to form these boards of citizens that are appointed by and approved by
No, I get that
the
part.
local governing authority. Yeah.
I get that, but like this other that is investigating the state process that's investigating the severe bodily harm or death.
With that, right,
so that's separate from this administrative process. So they left that largely undefined, whereas we kind of went the route with the Office of State Prosecutor, kind of having a second look. They kind of ponder this agency that would be stood up and would have this independent investigatory power. I think they would, the vision would be that they would cooperate with the locals. State police would also play a role. And whereas we did just officer-induced death, they also had serious bodily injury in their version for what would come under the purview of this to-be-determined agency.
So they're investigators, are they prosecutors, or?
They did not do prosecution. They just did investigation and the final analysis.
Right, so it would be referred to the state's attorney after they complete their investigation. But if you, Senator, if you look at, there is a little bit of, I guess, guidance on how it would be structured on page 29 between lines 9 and 17. The agency is being established as an independent unit of state government. As far as who is employed, the guidance there is that the agency may employ sworn police officers and civilians to conduct its work. And again, that work is focused at shootings involving police officers and other incidents involving use of physical force by a police officer that result in death or serious physical injury.
So if you look at number 4 on the flow chart, so they refer to the appropriate entity. Does that mean the local state's attorney's office? Right. Okay.
Thank you, Mr. Chair. Just and thank you to the House for a good work product that's well intentioned, as is ours, of course. I just want to rethink the flag, not to debate, but just want to put on the radar screen of council, and maybe you can look further into this. So the first is the House allows anonymous complaints, and because they don't include an expungement provision, I'm just curious how those anonymous complaints work and whether there is any kind of a limiting factor on those anonymous complaints. The second thing is the House has the public defender and the state's attorney involved in the disciplinary process administratively, but presumably some of these administrative processes will become criminal processes in which the state's attorney, who may have voted against discipline on the administrative side, is then charging on the criminal side, or a public defender who may have argued on behalf of discipline is then asked to represent the individual. And so the issue of professional responsibility and conflict, I just was hoping to get a little more clarity on. And then the third thing is that the House bill allows suspension without pay upon a charge of misdemeanor, and kind of takes food off the table of some of these people. And I'm a little confused how that squares with the constitutional presumption of innocence. And so I just was hoping for a little more clarity on that as well.
So,
You don't need to answer now. I'm just saying
sure.
for future, as we go through this. And
I think I can give some clarity on some of those questions, but others I definitely will have to
I
look
just wanted to
into.
put them on the table.
Okay.
So I think moving on, this is a lot to digest, but one thing, Jamie, I'd be interested in knowing is when we talk about the fact that no records relating to administrative or criminal investigations of misconduct can ever be exonerated. I would be interested to know what other occupations exist in the United States that is prohibited from.
So I don't specifically know an answer to that, Senator. I would have to ask the library to do a little bit of research on that to see if they could come up with anything.
Obviously, there's a great deal to go through here, and this is like an iceberg with an awful lot under the surface and just a little visible on top at the moment. But picking up on what Senator Waldstreicher just said, I'm looking at that page. I don't have the pages here. I've got the conformed copy of the bill, I guess with all the amendments included. But it's section 3-108, which talks about this, the suspensions without pay. If the person is charged with a misdemeanor committed in the performance of duties as a police officer, so a police officer who allegedly who uses any force at all could be accused of assault or charged with assault. So it looks to me as if what is this organization, the Administrative Charging Committee Trial Board, if a police officer uses force and is charged with assault, that would mean automatically that the chief shall impose suspension without pay. That's as I read it on first blush. It's all very complicated, but my initial reading of it is that the chief would have no discretion, that the chief would have to suspend an officer without pay in such a circumstance.
So, under certain circumstances, that's correct, Senator. There's two provisions relating to suspension. There's the discretionary emergency suspension, which is part of subsection A in that 3108 section. So that's pending in investigative, administrative charging committee and trial board process. The chief can impose an emergency suspension with or without pay if it's determined to be in the best interest of the public. That would need to be limited to 30 days. But you're correct, if going on to page 37, subsection B, it does say shall. So it's shall impose an emergency suspension without pay if the officer is criminally charged with those specified offenses.
Right. Thanks.
I apologize because I feel like I'm asking questions. Are we to just write out, like, think of suggestions, or actually, like, consider amendments? Like, what is our process?
So tomorrow we're going to start. We'll dig into the weeds a little bit more. So start thinking about questions, thinking about where you want it to go. Just literally today is all about just understanding. So we'll get into the weeds a little bit more tomorrow. But this is just a cursory kind of 101. What did they do? What do we do? Let's go to Senator Jackson and then Senator West.
You may have just answered a part of that, but I can tell you, having sat through the work group for police reform, I'll be interested to see what my colleagues say, but I think we put together a product that everybody gave. And this product from the House, I know for a fact because I sat through those hearings and I sat on that work group, there was no giving there. And there was certainly no input from anybody from the profession, i.e. me. And so they're determined to do what they want to do. And quite frankly, Mr. Chair, I'll see how I feel in the morning, but I think we have a great product. And I'm not saying that we don't budge at all, but I'm not looking at that as the panacea, so that's just me.
Thank you, Mr. Chair. So I guess the first question is, where do we start? So normally, if we got a bill from the House, we would take the bill and we would work on the House bill. And if when the House gets our 9 Senate bills, they would take our Senate bills and work on the Senate bills. That sounds like an awful lot of spinning wheels. It strikes me that maybe the better way would somehow to be go in a committee of the whole and work together, a la conference committee, because these bills are so different.
Yeah, before we get into the process, I just want folks to understand what the material is.
Okay.
So, and that's all that today is about. So I just want to just for folks to get just that understanding of like where we can start from. Then we'll talk about the process a little bit longer later on. But let's just understand what's in the bill. I just want to keep us on point with that, and not
Makes sense.
Yeah, delve down into the process too much.
So I'll turn next to use of force. So use of force starts at, in substance, at page 55. So there's a number of definitions that precede this language, and there's an aspect, I'll just start with lines 15 through 18, requires a police officer to sign an affirmative written sanctity of life pledge with respect to every human life and act with compassion towards others. Moving down, we have the use of force standard. And I'll just read from line 23. A police officer may not use force against a person unless the force is necessary force and proportional to prevent an imminent threat of physical injury to a person or effectuate an arrest of a person who the officer has probable cause to believe has committed a crime, taking into consideration the seriousness of the alleged crime. A police officer may use force only after exhausting reasonable alternatives to the use of force and only until the use of force accomplishes a legitimate law enforcement objective. Turning to the next page, this is page 56, provides for, just at the top of the page, when a police officer is required to cease the use of force. An officer is required to cease using force as soon as, one, the person on whom force is used is either under the police officer's control or no longer poses an imminent threat of physical injury or death to the police officer or another person, or the officer is required to cease the use of force as soon as the officer determines that force will no longer accomplish or is no longer reasonable and proportional to accomplish a legitimate law enforcement objective. Moving down, beginning at line 10, there is a distinction for use of lethal force. Lethal force may not be used unless three circumstances are met. That being that first, lethal necessary force, and I do want to sort of interrupt myself there. Necessary force is a defined term, I believe. Oh. I might actually be wrong about that. Okay. So lethal necessary force is used as a last resort to prevent the imminent threat of death or serious physical injury to the police officer or another person. 2, the use of lethal force presents no substantial risk of injury to a third person. And 3, all reasonable alternatives to the use of deadly force have been exhausted. There may need to be a technical correction there. We use the term lethal force everywhere else, but then it switched to deadly force. So there's a couple of duties that are imposed starting at line 19. There's a duty to de-escalate under certain circumstances, a duty to intervene under certain circumstances, a duty to render aid under certain circumstances, and also we'll call it a duty to document use of force incidents that the officer observed or was involved in, and that's just between lines 20 through 30 on page 56. There are requirements for police supervisors, starting on page 57. Police supervisors under the bill are required to respond to the scene of any incident during which a police officer used physical force and caused physical injury. They're also required to gather and review all known video recordings of a use of force incident. lines 10 through 18 provide for additional training for the use of force. Officers are required to sign a training completion document stating that the officer understands and shall comply with the Maryland use of force statute. There is also a provision beginning at line 22 for less lethal force training, and it provides that all police officers shall undergo less lethal force training and be trained and equipped with less lethal weapons that may assist the officer in controlling resistant or assaultive behavior.
Sorry.
Why don't we, Senator West, get a little bit further along and just kind of make notes as you go. I also have a couple questions, and then we'll just pose them at the end. And if they're answerable quickly, we can do it here, but otherwise we can just flag, and council can get those answers overnight for tomorrow's work session.
So just moving further, page 58 contains provisions on, this is still within the use of force subtitle, provisions on surplus equipment from certain federal programs. It's very similar to the bill that the Senate passed out. It does have a difference in that it applies to armored or weaponized aircraft, drones, and vehicles. I believe the Senate version was limited to those that were weaponized. There's also a provision that makes it apply to these materials whether or not they're assembled or in parts. So there's just a minor distinction there. Wanted to touch on it as we were going through. Starting on page 58, going through lines 26 on down, it provides that a police officer who uses lethal force against a person in a manner inconsistent with the provisions that I just read earlier, that results in death may be charged with manslaughter or murder under Title II, Subtitle II of the criminal law article. Those are the homicide offenses. And then moving on to the next page, an officer who uses lethal force against a person in a manner inconsistent with those earlier provisions that does not result in death may be charged with reckless endangerment or assault under Title III, Subtitle II of the criminal law article. There is a provision, lines 5 through 10, providing for civil action, and lines similar to the Senate bill, lines 11 through 20 provide for grant fund withholding under certain circumstances. And I think that rounds out that part of the bill.
Senator West was first, so Senator West, go ahead.
They used the phrase, less lethal force, and I couldn't find a definition of that. What is less lethal force?
So, Senator, the closest that I see in there is if you look at page 53, lines 29 and 30 provide for less lethal weapon. Means a weapon that is expected to create less risk of causing serious injury or death. I'm going to have to look to see if there's a more of a definition for less lethal force, but I'm not seeing one offhand.
So in the weapon area, that would mean instead of using a gun, the policeman could use a knife, maybe?
Expected to create less risk of causing serious injury or death. A knife doesn't come to mind immediately to me for that one. I tend to think maybe a baton or something like that.
What, like a billy club, like in England?
Maybe, or a taser, something that is expected to create less risk of causing serious injury or death. So the knife in that example seems like it would be expected to cause serious injury or death, but the baton example or the taser probably wouldn't. But yeah, the less lethal force isn't. I'm not seeing it defined in those definition sections.
Okay, thanks.
Yeah, sounds like we might need to flag that area, especially because a knife would be less lethal than a gun, but is not less lethal than a taser, which I think is what they're thinking of. So it may be a problematic area that needs to be resolved. Senator Lee.
Quick question, if you can answer it now, later it's okay. Does forfeiture qualifying crime apply to official misconduct?
There is a provision
Is that a crime of trustworthiness?
that appears, so just going back to the misconduct provisions, if you go to page, subsection E of page 38, lines 10 through 13, subsection E of 3108 provides that in connection with a disciplinary matter under this subtitle, forfeiture of a police officer's pension may be imposed as a disciplinary action in accordance with 20-210 of the State Personnel and Pensions article, which shows up
On page
later,
38, yeah.
later in the
Okay.
bill. And there is, the bill doesn't use it, but there is existing law on forfeiture for pensions as it applies to, I believe, constitutional officers. So the bill creates new language, but there is already existing language that that is in the code that pertains to that subject.
Would this also apply to mere theft?
I'm
Would
sorry,
also
Senator?
Apply to mere theft as well? Not really.
Theft. You know, it's tough to say because that provision of the bill applies to qualifying crimes, but this provision of the bill on page 38 doesn't necessarily apply to crimes. It may be something extra where it's saying that in connection with the disciplinary proceeding. So the forfeiture provisions later in the bill are tied to criminal proceedings and qualifying crimes. This seems more tied to just the disciplinary matter.
All right, I've got two questions, but I'll save mine for last. Anything from Senator Jackson? Okay.
Look, let me
Go
just say,
ahead.
I'm going to say this one last time. The House folks want to get rid of policing down to the mere thing of what they actually need, and when they get to what they need, it's only when they need it. So that's the mindset of what they did. It was the worst work group I've ever served on. I hope this is on record. I don't know where we're going to find a compromise here. Dealing with disciplinary matters and taking someone's pension. I mean, just look at the language. The language tells you exactly where their mindset is. They adopted some of the amendments that we put back in on the employment pieces. I got a call from the Speaker's office, from the analysts, to find out where the delineated pieces were from that, so they threw that in, but I don't have much to say.
Thank you, Senator Jackson. For those who are having trouble at home putting the pieces together, Delegate Jackson served on the House side on the work group that produced many of the recommendations of the House that you see in front of you, and so you had an intimate view of how these policies were crafted. Senator Bailey, go ahead.
Thank you. Same thing, because there's so many differences between what we're looking at here and all the time and effort that we put on this, and especially as my colleague Senator Jackson spoke about, and myself in our years in law enforcement. I am very curious, and just, going over this, there's so many questions. To put them down, just the intent is really an issue. But when we talk about losing pensions, when we talk about talking about how this section is, Jamie, I'd be very curious to know what other occupations are set forth in the same way. I mean, teachers have such a huge impact on the future of 10 or 20 years from now on what is happening. I've never seen us taking teachers' pensions like this. I mean, we don't do it with doctors, we don't do it with nurses, but I am interested if while you're calling the library, right, I am very interested to find this out also, because we are clearly creating a standard that is just much different than anything I could ever have imagined.
Thank you, Senator Bailey. And certainly we have to be careful about pensions because at some point you risk collective punishment, right? You've got spouses that rely on these pensions and children and grandchildren. So you have to be concerned about collective punishment. Senator Sidnor, I know you spoke eloquently on the issue of the use of force standard, and I just want to give you an opportunity if you had any questions about what the House is versus what the Senate is, or any issues or questions about the use of force standard.
Not at the moment. I'm still digesting, but thank you.
Okay. I didn't mean to turn this into law school, or I'm calling on people, but I just wanted to give everyone an opportunity while we're here. So. So just for me, two questions to flag for council. The first is the use of force standard that we adopted, and the Senate raises the standard substantially from a reasonableness standard to a necessity standard, which is what most states appear to have moved to who have reformed their use of force standard. But the House standard changes it to a proportional standard. And so I know we've got the NCSL tool that was provided, and I was hoping at some point tomorrow or later in the week you could, or I guess tomorrow is the later in the week, early next week you could provide an indication of how many states have moved to the proportional standard. And then the second thing is related to injury to third parties when there's lethal force. As the House passed the bill, and I flagged this concern previously, as the House passed the bill, an officer is not allowed to use lethal force where there is a risk of injury to a third party. Of course, in the last week, we've had two mass shootings, including one where the first responding officer was murdered by the mass shooter. In those situations, I imagine an officer has to act quickly to stop a danger, including the danger of a shooter with an automatic weapon. This is kind of the 9/11 scenario, but it happens much more frequently on a much smaller basis, including in the mass shootings we saw this past week. So just a quick question to council. If we could figure out how many states have adopted this risk of injury to third party standard, where if a third party is injured during a use of lethal force, that officer can be charged regardless of the intent of the officer. And so just a 50-stater, I think we could find that from NCSL as well. Other questions for council? All right, are we through the entirety of the House bill?
No, there are some other provisions that there were some distinctions on between the package that the Senate passed out and what's here before the committee now. We could sort of flip around, defer to you, Mr. Vice Chair, how you'd like me to proceed, but there is a notable section on no-knock warrants. There are also provisions on officer officer well-being, Public Information Act disclosures, as well as body-worn cameras, and then some other things that were unique, I think, to the House bill that weren't in any of the Senate packages.
So this meeting was scheduled to go to 3. We're at 3:15 now. So instead of a line by line on those, perhaps we could just do, as the chairman says, the wave tops on those, and just so that people are kind of acculturated to the differences, and then we can come back in more detail at some later point.
Sure. So the no-knock warrant provisions contain similar provisions to what's in the Senate package, but they are distinct. The application is done a little bit differently between the two bills, and the standard for a no-knock warrant is notably different between the House bill and the Senate bill. The House bill changes the requirement for obtaining a no-knock warrant. In current law, it is a requirement that there is the application show reasonable suspicion that there is either a danger to life or safety, or, and I'm paraphrasing the current law, or a reasonable cause to believe that destruction of evidence will result if the officers knock and announce their presence and authority. What the House bill does is actually changes that to a clear and convincing evidence standard. So in order to obtain a no-knock warrant, there would need to be clear and convincing evidence that there would be a danger to life or physical safety, but for obtaining that no-knock warrant. There are provisions providing for daytime execution of those warrants, much like the Senate bill, but worded a little bit differently and with different impact. And just sort of moving through, that's not exhaustive, but I'll just touch on a couple of more things with it. So MPIA for police records is done a little bit differently. The House bill grants permission to inspect personnel records, police misconduct, and internal investigation records to similarly to what the Senate did, but it also specifies that they need to be available to the Attorney General, State's Attorney, State Prosecutor, U.S. Attorney, subject to certain limitations. The bills require body-worn cameras to be adopted on or before 2025, I believe, and provide for tuition repayment program and scholarship funding for police officers. They have provisions, or the House bill has provisions on traffic stops and identification of law enforcement officers during traffic stops. As I mentioned before, increases liability caps under state and local tort claims, and alters requirements for certification of police officers through MPTSC. And I'll end there.
Thank you for the quick work on the differences on the other parts of the bill. Questions on these portions? MPIA, no-knock? Anything else? All right, we're going to shut down. I just want to flag 2 questions for council that I had. The first is on no-knock, which is the House use of the word exigency, which kind of goes to Senator Jackson's point. It's a strange concept to include in a warrant situation, because exigency is a warrant exception. So if there is exigency, they don't need a warrant at all. And this may accidentally incentivize people to not even get a warrant and to go straight to knocking on doors, knocking down doors, I should say. And so if we could get a little exploration of the exigency exception to the warrant requirement and how that interacts with the exigency language in the House no-knock, I think that would be useful. And then secondly, on MPIA, I just was curious, and I don't need this now, whether the House version, that's Anton's law, allows for anonymous requests. In other words, the officer against whom the information is being requested gets no notice that the information is being requested, or gets no notice of by whom the information is being requested. And if we could just get a little clarity on that portion.
Answer that for you right now.
Why don't we just kind of come back with all this tomorrow? I want to let folks go. I just kind of want to flag that for future reference. Anything else? Senator Bailey.
Mr. Chair, you brought this up, but you brought up Colorado, you brought up that shooting. And I think that it is important for the people who are listening to us to understand that Officer Talley was the first officer on the scene. He was a true hero. He ran into a gun battle as a police officer, and he saved countless lives as a result of that. And that is, when we talk about bills like the bill that we're facing, that is going to take a lot of work and a lot of conforming to get it so that we are able to be satisfied with it. The thing we need to remember is the people that we are very flippantly talking about are the people that are prepared, like Officer Talley did earlier this week, to give their life to save people. We need to be cognizant of that as we have these discussions. That's it. Thank you.
Thank you for that thought. Anyone else? Senator Carter.
You know what time we're meeting on this tomorrow?
I think the chair will make that announcement on the floor, but we're not meeting before floor tomorrow.
Thank you.
Senator Castle.
Between the House and the Senate version, on the disclosure of public records, is there any difference in how they define persons of interest? Is it the same?
I believe that's the same, Senator. That's a term that is part of existing law. Right.
All right, thanks.
I think this was really helpful. Thank you to council. Thank you all for today.